no idea what, once a month for 2.5 years. So there's no bad questions, but that's my introduction. That is way too long. So let's hear from you guys.
My name is Jaden Lewis, and I just started my licensing courses.
Awesome. So Jaden, so you just started, so you're not licensed yet?
Not yet.
So you're still learning. Cool.
Yeah.
Cool. Awesome. Thanks for joining us, Jaden.
Tyler Jeffries, and I've been an agent for about a year, but I'm just now getting started with it.
Cool. All right. Thanks, Tyler.
I'm Holly Odie. I've been licensed since May.
Sweet. So Holly, licensed since May. Okay.
Yeah,
It's your
not on a
first-
team or anything, so I'm actually like a dual career
Awesome.
agent. I also work part-time as a nurse practitioner, so.
One of my teammates started as an ICU nurse.
Yeah.
And did double duty for a long time until this past year. So
Love to leave healthcare, but
yeah. It's honestly is a good way to get into the business. So awesome. Thanks.
Hi, I'm Heather. I've had my license since 2022, and I actually started out as an ISA on Brady's team. Just recently decided I wanted to step into the role of an agent, and I'm now on the Litton Keys team.
Awesome. Cool. Thanks for joining us.
Thank you.
So, and last but not least,
I'm Destiny Rao. I was licensed in 2002, but then I had the opportunity to enter the appraisal industry. So I've been appraising for the last 20 years and then decided, well, I've got this other license. Let's learn how to use it. So here I am.
The other day, right?
I think
I
so.
think I did, yeah.
it's a good background. I would say. So how familiar are you with these forms?
Not
Not
very.
very cool.
When I did this back in 2002, there was a filing cabinet at Remax in the hallway and we pulled out the documents that had the carbon copies. So
Awesome.
it's been a minute.
Awesome. Well, we will jump into that. So
Okay.
we've got Crispin online. So I believe we've got it to where you can unmute yourself. If you want to say hello, we can hear you from the heavens, maybe. Crispin? Come in, maybe not. Okay. Zoom is always like hit or miss. Like I'll call people out by name and they're either like there or they're like off feeding their cat or something. Yeah, it's just, who knows? All right, well, let's jump into it. So we're gonna talk about buyer forms today. We've got right at 2 hours, so 3 o'clock is my cutoff time. We probably will not get through all of these forms, so I wanna make sure I'm as efficient as possible on the most important parts. And just understand that you have a huge office full of people. You can literally walk around and if you see a door that's open, chances are they're open to you asking for help. So if you guys ever get stuck, let me know. Or let anybody else know. You wanna let me know, this is my cell number. You go straight to me. It could be 10 o'clock at night and you're like, oh my gosh, I have to write an offer and I have no idea what's going on and I can't get a hold of anybody on my team or the broker or whatever. I may be asleep, but if I'm not, I'll help. Sound good?
Yeah.
Cool. It just may be with a bourbon in my hand, so don't judge, all right? Awesome. So let's jump in. So I've got some physical copies up here. First of all, while we get these going around, all of this stuff is digital as well. You get everything on DocuSign. So we'll start that around. So bear in mind that the most accurate way to do this is view those electronically. I'm gonna start with 2 and then we'll get to the other ones if we have time. Everybody got one?
We're missing.
Missing one? Okay, ooh, awesome. So we've got this last one. You're missing one of the exclusive agency contracts?
Possibly, I don't know.
I don't know what I have, so I don't know what I don't have. Okay. All right.
You wonder if you can grab one of those pens?
Nope, no.
there's an extra one of those.
Oh, cool. Sales contract. Awesome. All right, cool. So we're gonna go in order of operation, the way that you would actually work with a buyer. So we're gonna start with hiring, which would be your exclusive agency contract that you have. And I'm gonna get logged into DocuSign so I can follow along since I don't have a physical copy.
these ours to keep? Like, we can like take notes on them?
Yes, you
or-
can. Yeah, you can take notes on those. We can always make more copies. That's not a big deal. Thank you for clarifying that. I don't want you to, I mean, highlight them, mark them up, write questions in the fields. All of that jazz. Okay. So when you go into DocuSign, you will always start by default in the e-signature, which is really confusing if you're trying to find contracts. So just know that you can click on your profile picture here on the right and go to switch to rooms. And this is where all of your transaction management will actually occur. Now, you always want to start with command and then filter in. I'm sure you guys have seen that with some of the classes that maybe Nicole has taught, right, on how to link those. We're not going to do that today. We're just going to talk about the forms. But if you have trouble with that, make sure you're reaching out or go to one of the tech-based classes too. So for the purpose of today, though, I'm just going to create a room. I normally wouldn't do this, or you normally wouldn't do this unless you just need to play around with forms. But it's honestly, it's a good way to play around with forms. So we're just going to say, oh, 65. Nope, 65721 zip code. And I'm going to name the room. We'll do contract class 9-7. And we'll do both sides. Cool. Save, we'll create a room. Room is successfully created. Okay, cool. So this will just give me the ability to jump in here and pull documents. And honestly, it's a good way to like explore the documents that we're not going to cover. There are hundreds of documents. Pretty much anything you can imagine for any purpose is in there. Great example. I mean, just this morning, I'm putting a commercial deal together that is actually is owner finance. So I have a seller financing rider and a commercial contract that's in there too. So all the forms are in there, but the primary ones that we're going to talk about are just the residential buyer side for today. So the easy way to do that is go to add, go to DocuSign forms, and these packets here very much work like physical packets. This is what the office has put together to make it easier for you to find the most commonly used necessary forms for you to use within that scenario. So since we're working with a buyer, we're going to click on residential buyer documents, and guess what? It has pretty much everything that we would need for the signing of a residential buyer. Now, when we have to write a contract, we'll go into residential contract documents, and guess what? Now we have amendments, counteroffers, offers, we have the real estate contract, final walkthroughs, all the stuff that we would do to facilitate the negotiation of the transaction. If you're listing a home, same thing, click on the listing, and then there's miscellaneous. But if you want to search all of the forms available, these libraries have every form. And the MAR is basically going to be a searchable field for anything you could possibly imagine, right? So if you search something that you think might exist, it's probably in there. The MAR forms are the ones that you want to use. There are KW specific forms too. So like if you needed a referral form for an outside referral, you can find stuff there. The board has their own forms that occasionally you'll use, but for the most part, you'll stick in these packets, and we'll stay in the buyer section right here. So this one, you guys don't have a physical form, but I want to talk about the broker disclosure form. Let me find it. And actually, we'll go ahead and pull in the agency contract, and we'll pull in all of these just for fun. We're not going to cover all these little ones. I call these CYA forms. Anybody want to guess what that abbreviation means? Cover your tail. CYA. Okay. So stuff that we require, and a lot of this stuff you don't have to do on the front end, strictly speaking, but for compliance, you'll have to do it on the back end. So I tend to try and get them all in. So affiliate referral, stuff like that, before your protection, all of these, home warranty, all of those are the basic ones. But if we actually look at the Missouri Broker Disclosure Form, this is the one that you guys might remember from your MREP class, or if you haven't got it yet, you'll hear about this. This is the most important form that is most often not done correctly. And it is the Missouri Broker Disclosure Form. It is, if you have a meaningful interaction with a buyer or seller, you should have them initial this form. It's not an agency agreement. It's not tying them to you exclusively whatsoever. It's just an acknowledgement that, hey, because I'm a licensee in the state of Missouri, I have a legal obligation to let you know what your options are as far as real estate representation. Does that make sense? So it's really basic, and it's a good thing for you guys to know if you're ever curious about what are all these different types of agency. It spells it out right here. I mean, you can see all the choices available to you in Missouri. Sellers or landlords, limited agent, buyers or tenants, sub-agent, which is agent of the agent. We very, very, very rarely use that. If ever, you guys may not run into that at all. That's typically done in rural areas. It's where, for example, an agent outside of the MLS is going to transact and they don't strictly have access to this area, so it's, they're a sub-agent of you. But the problem with that is that means that there's liability there, so we oftentimes don't do that type of representation. And we have disclosed dual agency. Anybody remember or know what dual agency is? So somebody shout it out. What is dual agency?
Representing both sides.
Representing both sides? Okay. So what's the difference between dual agency and transaction brokerage if you're still facilitating both sides?
Transaction broker just handles like the paperwork, so they don't represent.
Fiduciary duty.
Yeah,
Correct. Correct. So notice I got fuzzy. Everybody was like, eh. You know, it's funny, if we had a room full of agents that have been in here for years and years, they'd probably still react the same way. This is a confusing topic. The best way that I can describe it in layman terms is dual is both, transaction is neither. Because you're really not, at that point, advocating for either party. And oftentimes agents will put transaction brokerage, when it's really not accurate. For example, I have dual sides for a buyer who is purchasing a for sale by owner. My representation with the buyer is pretty straightforward. It's going to be a buyer's agent, buyer's limited agent, as well as a designated agent. So that's that checkbox. It's another layer of agency, meaning not only am I representing them as a buyer, I'm also representing them exclusively. So they don't have that relationship with any other agent. And I'm also designating myself separate from the rest of my office as well. And that's important because technically, if you don't have that designated agency, everyone has agency, right? If I wrote an offer on a listing that one of you guys had, and I didn't have that checkbox, and you didn't have that checkbox for the seller, technically we'd be dual agency because we're both in the same company or brokerage. Does that make sense? So that designated agency allows us at our office to represent Keller Williams on both sides, but different agents, and still have full representation for all parties, which is why our brokerage tends to default as a designated agent. Not every brokerage operates that way, but typically that's how Don and Jim and everybody here, that's what they're gonna expect you to have in most cases, is designated agency. Does that make sense? Cool. So back to the for sale by owner. So I have a buy side representation and I am a buyer's designated agent. What am I to the seller? Am I guess? I can stand here until 3. I'm just kidding. Yeah. Shout out there. What do you guys think? You think it's designated agency, transaction brokerage, dual? What's most appropriate?
transaction maybe.
Transaction? Okay. Anybody want to say for or against that?
I'm taking a guess. I don't know.
You just made the assumption that almost every agent makes, and I understand your logic behind it, and it's wrong.
So that would mean you're not representing either party.
Correct. That's why in layman terms, I explain it as both or neither, because oftentimes people think, oh, well, I'm a transaction broker for the seller, but I'm a designated agent for the buyer. That allows me to facilitate the sale. I'm not representing them, so it makes sense, right? Other people would say, oh, it's dual agency. Anybody want to make an argument for dual agency?
You're not,
You're not, why?
because you're not a designated agent for the seller. So if the
Well, you would be if you signed paperwork with them right then and there for the process of filling out an offer, and a lot of agents do it, even in our office.
Did you do that?
For a while until I knew better.
I mean, in this case, did you do that?
No, of course
Okay.
not. No, I didn't. So the reason why that's not appropriate is, I have a fiduciary responsibility to the buyer all the way up until I write an offer. At that point, if I go dual agency, now I'm saying that I have an equal interest in both parties. And that's not actually true. I don't know the seller's motivating factors at this point. They're representing or listing it themselves. It's not that I already had that seller and I already had that buyer and now they're being put together. If that were the case, it would be dual agency. I've already done a full listing consultation. I've done a full buyer's consultation. I know the financial information. Now I'm in the middle and I'm representing both parties in their best interest by sharing anything that would be factual or potentially have an adverse material impact on either party, right? That's dual agency. In this case, the way you would actually fill out your contract, we'll get to this when we get to the sales contract, is on the buyer side, you're a buyer's designated agency. On the seller side, you are a buyer's limited designated agency. So buyer's limited agent and a designated agent. So you're the same. You're representing the buyer in both instances. Which if you think about is factually true, right? Because you're really there and facilitating the deal on behalf of who? The buyer, right? Does that make sense? Cool. That's super confusing still to a lot of people. I know this is one little form, but I wanted to hit that issue because you absolutely will run into that. And 9 times out of 10 people do it wrong. And if you never go to court, no big deal. But if you do go to court, if you get audited, it's a real big deal. So make sure you guys know the difference. Make sense? Cool. All right. Any questions about this form? By the way, here you just check all the boxes. And I literally go through it. I check every single box. Like this, except for other agency relationships. This is basically stating, hey, my brokerage authorizes all of these things, which is true. Keller Williams will authorize any of those within the right use or instance. And then down here for broker or entity name, you would just type in Keller Springfield or something, or Keller Williams Realty or something to that effect. Any of those are valid. And then you're gonna put in the address, which is 1619 East Independence Street. And so on and so on. So Springfield. Four, cool. So this would be a properly filled out form and you would have the buyers or buyer, if there's multiple, you have both initial both pages. That's it, not a signature. Not choosing one agency type. This is just an acknowledgement for them that this is what's available to them. Does that make sense? Cool. You cannot get paid if you do not have this form in your file. It's required on every single deal. Any questions on that before I move on? Cool, so we'll save and close, so it'll be in here. Ta-da. Now we'll go into the form you actually have, which should be buyer's exclusive agency contract or the MSC 1080. Now everybody should have that physically, right, in front of you. Everybody got a copy of that? Cool, all right. So before we jump into this, anything that you guys want me to make sure I hit when we're covering agency? Any big concern that you have? Or is it just, I don't know what I don't know, tell me what I need to know? That's okay too.
I have one.
Yeah.
I just got done doing one of these yesterday and I thought about it after I'd done it. LLCs, if you don't, does that go in place of, because it auto populates that with names when you fill out in command, I think it fills out their names. Well, I wasn't paying attention, but I think it's gonna be through an LLC. Do you put that LLC in your top in place of their names, or is it that big of a deal?
So, yeah, this one's easy to get tripped up. That's a really good question. Who is purchasing the property? The entity or the person that has an ownership or management stake in the entity?
So I mean, it's essentially gonna be the entity, but then they're gonna be signing on it.
Correct. So you just answered your own question. So, two common mistakes happen with LLCs, which is pretty common. You work with investors, or if you're purchasing on behalf of yourself as an investor, it's really common. They'll either put the person's name instead of the LLC, of the entity name as the buyer, which is wrong, or they'll have, because DocuSign automatically does this, which is kind of frustrating. They'll have them sign as, hey, you know, Pebble Vistas LLC, right? Instead of signing their name. Well, you have to have the name, you want any of the name fields to be the entity. And you want and the printed underneath, you want to be the entity. And then in the signature field, the way that I personally do it is I put it as the name for the entity, which you typically have to manually change. It doesn't automatically populate, but because you can't have an entity sign for itself.
Correct.
You have to have a person that's attached to it, and the person has to have the documentation stating that they have a right to sign for the entity, because the title company will have for that.
Yeah.
So for me, if I were buying an investment property from my LLC, I would sign it as, and I'm gonna print this just for the sake of putting it would be Brian Stone for Pebble Vistas LLC, for example, right? So that's what I would actually put in the signature field. You can also just have them sign as their name, and you can put a text box next to it that says for, and then the entity name if you want. Some forms actually have a section at the bottom that says if signing for entity, place it here. If that's on the form, you can do that. That's totally appropriate, but otherwise, this is what I would recommend. Is the person for the entity in the signature field. That answer your question?
Yep.
Cool. That was a really good one. Thank you. So outside of that, what are we putting in this top line? You guys can fill along as we go. By the way, I'm buying this property, so we're gonna put my information in here for everything, right? And the address won't surprise you. It's 123 Main Street. That house has been sold. Nobody likes it. So, so if I'm the buyer, what am I gonna be putting here?
Name in mind.
Your name, yeah, cool, yeah, it's not super complicated, so yeah, you're gonna put your name, cool. And we're gonna go over this manually. Actually, no, I changed my mind, we're gonna make this super easy. You guys want the short way?
Yes.
Say yes, yeah, okay. Details of DocuSign, this is your friend. Click on the details tab if you're filling this electronically, hit edit. You can put in all the information here and it will auto-populate a lot of your fields. So this is what I do when I'm prepping. So for example, we'll do 1, 2, 3 Main Street. City is Springfield, surprise, surprise, county, green, state, not Maine, Missouri, postal code 65804. Cool. All right. So we have the address in here. And then we're going to have the names populated. By the way, if you start in command like you're supposed to, it will auto populate from the contacts in command. So this part actually becomes easier. But if you're not, then you can still do it this way. So we'll say, I'll just do the buyer, wherever it is. Buyer one. Brian Stone. Buyer 2. That's my wife. She's buying 2. She's definitely. Okay. And I could fill in seller name, all of that stuff if I needed to, but I only worry about filling out the side of which I represent. So for the purposes today, I've just put the buyers, and you can put yourself as an agent to it, but a lot of that will automatically populate for you. So if we do that, now look what happens if we go back to a fillable form. Now keep in mind, these are only these that you pull from the DocuSign forms. Any PDFs will not transfer like this. It has to be a dynamic form for those autofill fields to work. But now if I go in here, it's gonna automatically populate all the stuff that I have in that area. I don't recommend doing any more than just the basics like name and address, because it'll throw off some of your fields where you may wanna make some changes and do it manually. So you can technically put your price in, your earnest money amount, all that stuff, but I wouldn't So as you can see now, it automatically filled in exactly what it's supposed to be. Hey, Brian Stone, Melissa Stone. In that order, that's how they put it. That's a perfectly valid way to do it. Now for company name, it's missing, it says insert brokerage company name. Who would that be? Yep, Keller Williams. So yeah, it would be in here. Keller Williams. By the way, if the buyer's agent portion was filled out and it had your company in that field, this would also autofill. So again, a lot of this stuff is gonna autofill for you, but I think it's good to know how to do it in paper too. So we've got that, and what type of property is this? Well, it's a residential, so we're just gonna click residential. If it was other, I could choose other, like multiple. If it's commercial, I could do commercial, so choose what's most appropriate. Then it goes into for the period beginning with effective date and ending at 11:59 on blank day of blank month and blank year. So what is effective date? Do I know what that term means? You will see this a lot. Effective date means the date of the last required signature of the said document, right? So effective date would be the date that they sign. If you send this today and they don't sign until tomorrow, the effective date is not today, it's tomorrow, right? Because that's the date of their signature. Does that make sense? So cool. You'll see that in a lot of the forms. Anytime it's referring to effective date, it's the date of the signature, the last signature. What's a typical agency period? What's appropriate? What do you guys think? How long should we sign Brian as a buyer?
6 months to
Six-
a year.
6 months to a year? Okay. That's what I guess.
I was gonna say 30 days.
30 days? Okay. I'm picky. We're not gonna find anything in 30 days.
I guess in this market, no. Years ago, when it was busy, we put 3 days on
The
everything.
right answer is long as you reasonably can. Right? Because you want to have that relationship. Or as long as it makes sense. I typically do mine for 6 months at minimum. I usually start at a year unless I have an objection. I'm gonna give you guys a tip too. This is more for the sell side than it is the buy side, but it applies to the buyer side too. Every single field in this is a term that you can negotiate off of. Every single one. So if I have a transaction fee and the buyer doesn't want to pay the transaction fee, or if I have a listing and they want me to take it for 5%, I will negotiate my time before I negotiate my money. Does that make sense? So if I started a year, let's say I'm signing a listing, I know this is a buyer class, but listing is usually where this comes up. Say I want to sign a listing for a year, like, oh, well, we're gonna know before then, and if you can't sell my house in X number of days, then I don't want to work with you. So, okay, great, well, why don't we do 6 months? That's half of what I typically do. Now, they still don't say it. If I'm really confident that they're gonna price it effectively and it's a good listing, I may even do a 30-day listing agreement. And then I'll extend it when it goes under contract. I could do a 1 day. Well, hey, give me a day, right? If it's the right price and the right house, that's all I need, right? So you can put in whatever amount you need in there. I've used 1 day for buyers that are reluctant to sign an exclusive agency. They're like, well, I'm not gonna sign anything. I just want to look at some houses. Cool. I'm not gonna show you houses unless you sign something, right? So you can have that whole battle. I had someone flying from out of state one time and he was gonna be in my car while I was driving him for 4 hours to look at multiple properties because it was the 1 day that he was in town and I was picking him up from the hotel. Do you think I'm gonna do that without having an agency agreement? The answer is no. Other agents would say, yeah, sure, I don't have anything going on. No, the answer is no, you don't do that, right? Because you want them to have some skin in the game. So, but hey, guess what? We're gonna sign a 1 day agreement and anything I show you today, if you buy it, guess what? That means I have procuring costs and you owe me a commission. And I'm gonna be your exclusive agent. And that's how it's gonna be. And if you're not okay with that, really hope you enjoy being here in Springfield for the day. I'm not your agent. Fair? Cool, all right. So put in this time frame whatever you want. So like I said, I usually do a year. We're gonna say 9th day of September. 2024, we'll just say, hey, let's just sign them out for a year. It's Brian Picky. So. Motivating factors. So this one, either is fine. If you put does, you do have to put what they are in this field. If you put does not, you don't. So this basically means, hey, is the buyer, because you said, you notice it says buyer check one. Is the buyer allowing you to share the motivating factors? So basically, do they permit you to disclose it, right? So some cases, the buyer does not want that done. If you know that they're a very private person, you want to have a discussion about this field and say, hey, if you want to make sure that I have a block and tackle way to block your interest, let's put does not, because that way if anybody asks why you're buying, I can just say, hey, unfortunately, based on my agreement that I have with my buyer, he has not authorized me to disclose his motivating factors. And then conversation done. I don't care how good the agent is on the other line. They can't get that out of you. It's legally an obligation. Most of the time I put does, because oftentimes I can use that as leverage. I can use their motivating factor to appeal to trying to get them a better deal or get them in the house over another buyer, whatever reason, right? I'm like, oh yeah, it's a first time home buyer and they've been searching for forever and they have 15 days to find a home, otherwise they're out on the street. Well, that may get them the deal, right? If that's more important to them than any leverage on price or other terms, then they want me to be able to disclose that. Does that make sense? If you choose does, I put all motivating factors. This allows you to fill this out without having to spell them out, but still giving you full, free reign to disclose whatever you need to in negotiation. This is how I most often fill it out. Because I do some verbal negotiation and I want to be able to do that unrestricted without ending up in court. Sound good? This is an important one. Current representation agreement. They either are or they are not a party in another exclusive buyer's representation agreement. We're going to hope the answer is not, because if it is this one, I have some questions as to why you're having a conversation, right? And that's okay. Is there instances where you would check this? Absolutely, but I want to reiterate too, don't cross this line, right? We shouldn't be soliciting people that already have agency agreements. This would only be an instance if they reached out to you, not the other way around. Like if they came to you, it's like, hey, it's my sister-in-law that came to me and said, hey, I really want to fire my agent and I want to hire you. So I don't want to use them anymore. And I'd say, cool, you need to talk to your agent because I can't represent you until that agreement is gone. And I also can't help you in figuring out how to get rid of that. I would say, call your agent. If they don't answer, call their broker. That's how I always answer that question. And then if that is the case, but they still feel confident they want to sign with me, or if we're close enough to where that agency expires and they're just going to wait it out and say, hey, my agreement ends at the end of the month, cool. Then we would mark is, and we would put in the date. We'll say it's 9/15. We'll say it's mid-month, 2023. Cool. All right. So they are a part of it, but I'm not going to do any real estate dealings with them whatsoever until after that is gone. And then this is effective. Does that make sense?
So your contract would still be effective, like on the date of their signatures, or this then changes that to when that
That would be,
current
yeah,
representation ends?
yeah, that
Okay.
would, this would not be,
So that would be your new date.
yes, yeah. Yeah,
Okay.
technically, still the effective date was when they signed, but, in reality, you're not gonna do any kind of representation activities because they still have that in place, and that would be a breach in ethics and a
Yeah.
breach in the agreement they have.
Okay.
Not necessarily by you, so it would be your buyer breaching the agreement that they have, the contract they have with the other agent. For you, it would be you breaching the agreement you have with the board as far as clear cooperation and not, like all the ethical stuff that you guys get trained.
Yeah.
Does that make sense? Cool. Any questions about that? Cool. We're gonna assume I'm unrepresented. So we'll put that back to where it used to be. Flat fee, what is this for? Anybody seen the flat fee? Okay, what's it used for?
I know there's some brokerages that like, they just do like 2,500 or, right?
Yes, so there are some flat fee brokerages.
Transaction, is that what that is?
So this is, yes and no. So this is intended to be for partial compensation. So what you're referring to, the flat fee brokerages,
Okay,
that's their full compensation is a flat fee.
okay,
This would be, above and beyond the, compensation. So if you look at it here, it says, you know, buyer shall pay realtor as partial compensation for services rendered hereunder in amount equal to X dollars. That flat fee together with an additional compensation due realtor is, it comes about as set forth below. And then you have three options: on effective date, which is right now, on and only at the same date of other additional compensation, which is most common, or not applicable. So I usually check, oh, this is a weird place. This box is actually the second sentence. So I would choose that, and then my fee would go in, oh, where'd it go? Oh, that's fine. Didn't have the numlock on, okay, so let's say I got a flat fee of, a fat fee, that's not a fat fee, fat fee would be like 1,000. $350, so we've got a flat fee of $350. And basically this means, if I'm explaining this to my clients, I'm saying, hey, this is my transaction fee, that's often what we call it, or flat fee. It's a transaction fee. This is only due, if we actually close on your home, and it's due at the same time. And even when I work with buyers, I say, hey, as long as the seller has already agreed to pay the compensation or the commission, which is typically any home that's listed, they have agreed to do that. As long as that's in place, this is the only thing that you, Mr. and Mrs. Buyer, will pay me as your agent. The rest of my compensation is no cost to you because it's covered by the seller. Right? But this flat fee or this transaction fee is not charged to the seller. Only your commission percentage is. Does that make sense? So this is above and beyond your commission. So there's lots of uses for this. A lot of agents shy away from it when they first get started with zero. I was a coach here for a couple of years before Shanna for our office. I used to always tell my coaching clients, write it in every single time from day one. Just make sure that you're being transparent about what it is. The easiest way to say it is, hey, this fee goes to my transaction coordination. It allows us to have someone that handles the file from start to finish once we go under contract, which makes it easier for you as a buyer because my time is focused on negotiating your wants and needs and not on paperwork. Which is true, right? Because I can turn around and take this $350, $250, and I can pay a transaction coordinator. I can call Onward, or you know, I can if you're on a team, you know, there's a portion like you have a transaction coordinator that's representing that, right? So that's a lot of teams have fees that they require, where they're like my team, everybody that writes a buyer on my team puts that flat fee in. As if the client doesn't pay it, then they pay it. Because that's a team expectation, because of all the value we're providing as that additional compensation. Does that make sense? So
who does that fee initially go to?
it goes to you
Okay.
as the agent, or it goes to whoever the team is, or, you know, whatever your compensation is.
Okay.
The unique thing about the flat fee too, is your royalties come out of it, but your cap does not. So if you truly want to offset a $250 transaction fee, only 6% of that is going to come out until you pay your royalties, and then it'll be zero. So what's 6% of $350? You guys have the magic like calculators that you call from.
What was it? $350.
$350.
$21.
$21, okay, so we're still at 325-ish or 330, right? So and most of your for a buyer, I think the fee for Onward is $250,
Yeah,
right?
yeah.
So you're covering that plus a little, even after they take royalties out, so you can truly offset. And what can you do with the other $50? Pay for your gas,
Yeah.
right? Seriously, like, so, I mean.
Bottle of wine.
Bottle of wine, closing gifts, right? Do whatever you want with it, right? Put it to use back into your client or into your business, which in turn benefits your client, but don't be afraid to charge a fee. Does that make sense?
Does that show up on that, does it come out at closing? Will
Yes.
it show up on the closing statement?
Yep, it'll show up on the CD, on the closing disclosure. You have to make sure they do it. which if you have a TC, a transaction coordinator, they'll follow up for you, make sure that it's there, because that's how they get paid too. But yeah, it'll come out at closing. So again, you don't have to do this, and you can put whatever you want.
I just had my first listing and I was hesitant to charge it. But I mean, they didn't even bat an eye.
Yeah.
Cause I explained like, this is essentially kind of what you said, like it's for transaction coordination, dotting all the i's, crossing all the t's, making sure everything, goes as smooth as possible and okay.
In the absence of value, price matters.
So,
If you provide enough value to charge, to be worth what you can charge what you're worth. Fair?
so do most people just use like what the onward fee is?
All across the board. A lot of people put 0, but
Okay.
some people put 600, 500, whatever they're, it's that, you're an independent contractor, you can do whatever you want. It's completely up to you. So if you do something super special for your clients, then go ahead, by all means. And this is not a sales class, it's a contract class, so I'll try and hop off my soapbox and not hang around there too long. But yeah, you can charge whatever you want. Cool, make sense?
Yeah.
It should be higher on the list side on the buy side than on the buy side if you guys decide to do it. Because typically your transaction coordination is higher on the listing side. So usually 350 without the 6% being taken out is what your transaction fee is going to be on the list side. So you may want to put 400 if you want to cover that fee completely. So up to you though. Cool. Additional compensation. So here's where we get into the actual compensation. So you could put in the dollar amount like you were talking about, so the flat fee.
Okay.
Flat fee representation, that's what they would do. They would put in the flat dollar amount here. And guys, we do allow that. If you want to run your business that way, we strongly encourage that you have your bottom be at least 3%. And typically this never comes in play with buyer's agency, but in a listing agency, if you're capped, you can charge less than that. I think anything less than a 1.5%, if you're non-capped, you're gonna have to have approval from the office. So you can't just, start slinging deals out and be like, oh, I'm only gonna charge $50 because then they're providing all this value and not getting their percentage back, right? So.
What's the meaning of cap versus non-cap?
So your cap means, so you're either on an individual agent cap or team cap. So you're individual agent, right? Or, okay, yeah, so if you're coming as an individual agent, your cap is gonna be 20,000 for the market center here, and then 3,000 for the royalties for Keller Williams International. And that resets every year. So once you pay your cap, you're getting 100%. So the office doesn't take any percentage out.
Oh, okay.
Does that make sense?
So the cap here is 20,000, you said, and then that's how much they can take from.
So, yeah, so that's, once you hit that threshold, that's the maximum amount that they'll take out.
Okay.
So it caps out at that amount.
All right.
Until you get to that point, that's when you have your percentages, which is, I don't know what it is now, but, because I think mine's different now, but yeah, it typically is what, 60, 40? Or 64, 36, something like that. I don't think it's that high either. I don't think it is. Ask the office, I'm not the person to ask them. I cap every year, so I pay attention to it. So,
It was 20 and 6 for royalties. I don't know.
it could be 20, it could be 20. I do know it's different for team members.
I think you can choose maybe
There's options
like
there.
a 70-30. Anyway,
Yeah, there's
We'll go
options.
over that with
I know it's
your
70-30, I think you're right.
already
It's 70-30. You're right. Yeah, I think that's the default. Sorry, whoever's listening on Zoom, if I misquoted that, very, very sorry. Talk to Mike and Nicole, I'm gonna tell you. So, we're gonna assume that it's 3, so we'll put 3 here. And we'll also write the word 3 here. So it's 3% and then parentheses 3%. So we're reiterating it verbally and then as well as being there. And then down here, this talks about your protection period right here, this field. So the protection period goes into effect after this agreement is over. So we wrote it in through a year. So after a year, if I still don't find myself a house and I don't rehire myself, the protection period would be how long this agreement would still be in effect for any houses that were procured for that particular buyer. So if you're doing like a 1-day agreement, like I was talking about, I'm gonna do like a 6-month protection period. But typically I do anywhere from 30 days all the way up to 120, depending on how long I've signed them. So if it's a longer signing, you usually want longer protection period because that's a lot of showings over time. So we'll say it's a year. So we're gonna make that 120 days. So in other words, if on a year and 1 day, my buyer decides he's gonna just go to this listing that I showed that's now off the market and never sold, and then talk to the seller, and they're just gonna sell it between themselves, and they're gonna wait until this expiration hits so that they can cut the realtors out of it, right? This protects that from happening. Because they're obligated to still pay that commission if I procured that listing for them. Does that make sense? You can challenge
We'll do a
it.
year on there?
I do a year on my representation. I do 120 days
120,
on my
okay,
protection period, yeah.
okay.
Now, this protection period is null and void if they sign an agreement with another agent. So if Destiny is like, hey, Brian's a terrible agent, you gotta sign with me, and they're like, yeah, you're right, he's a terrible agent. Then, and the day after they sign a new buyer's representation agreement, guess what? The protection period is null and void, doesn't matter.
So even if they go get the same property that you showed,
Mhm.
so you would.
And they have a new
actually
agency
be
agreement in
procuring
place, yeah.
cause, it doesn't matter now, cause I've seen some of those posts, like, where that
There's
happens.
people that try and argue it,
Okay,
but it's not a battle I would recommend.
so this is only if they're not represented.
Correct.
Okay.
Yeah, and the way that I explain this when I'm going through the client, like, hey, this is a protection period. This is just to keep you from waiting out the contract period and then going to try and buy a property that I showed you without the seller having to pay my commission. It just protects me. I'm just honest about it. Because if you say that, they're not gonna try anything. I promise. If you don't, they might. Depends on who it is. So, does that make sense?
Yeah.
Cool. This just details the protection period, basically summarizes everything that I just said. Non-performance and termination is here. Yeah, basically this is saying it's, if the contract is not closed by reason of non-performance by the seller or terminated because of failure, contingency, or defect in the owner's title, the realtor shall retain the amount of any flat fee that is due and payable as of the effective date, but shall not receive any contingent flat fee or additional compensation agreed upon. This really doesn't come to play. In other words, if you were to take a flat fee up front and not have it paid at the same time as closing, then this is just stating that you don't have to give that back. They've already paid for your services for that. But almost no agent does it at the time that you sign up. Almost everybody does a flat fee on the back end. So that's probably gonna be a non-issue. And I will tell you, I don't burn bridges in business. It's usually not worth it. So if this were the case, I would probably still give it back to them because I'd want to maintain a relationship. So, cool. This is basically a further explanation of what we just went over in the broker disclosure form, but it has it in their agency agreement. And this is them just checking they either consent or don't consent to these different types of agency that we talked about earlier. So I typically would put yes on all of these except for transaction brokerage, because I don't like transaction brokerage, but you could just do yes on all of them and that would be perfectly fine. So it's basically them saying, hey, if we need to convert to dual agency, then yes, we can do that. Hey, if we need to, convert to transaction brokerage in this example, then yes, we can do that. If we need to go to designated agency, then yes, we can do that. Basically, them putting yes on this is them acknowledging that you can change your representation type based on what's needed with proper disclosure without having to redo all of your employment paperwork. Does it make sense? So I usually don't have any pushback with people just putting yes all the way, because they're like, hey, this just prevents us from having to do paperwork. If for some reason I have to change the representation, like say it's a listing that I already have and it's a perfect fit for you, we have to change the dual agency. It just means that with your consent, we can move forward without having to do the paperwork. They're like, cool, Does that all make
Yes on
sense?
all of those.
Yeah, I just put yes on all of them. That's the easiest way to remember it. Because you're not gonna have to worry about it if it's all yes. If they're all no, then you'd have to redraft it every time.
Okay.
So this goes into buyer's obligation. So I love covering this with a buyer. I'm like, hey, we talked about in my job description. Here's yours. This is what the buyer is agreeing to. This is a contract. And it's two ways, meaning they are agreeing to exclusively deal with you, to supply whatever information is required. That could be financial or personal data. Even though you have an obligation not to disclose that, they have an obligation to tell you for the purpose of the transaction. And this is that agreement. So if you get any pushback midway, like, well, hey, how much is in your bank account? Well, I don't want to share that. Actually, the agreement you gave me said that it's commonplace for me to request financial information because that's how I best represent you, right? So it gives you a little pushback. Same with availability. This cracks me up. I always make a joke of this with my buyer's consultations. Yeah, this says that you will be available during realtor working hours to view properties. And I always kind of look at them and they kind of smile. I'm like, I haven't figured out what my working hours yet. And they usually crack up because it's like, hey, whatever, I work when other people don't. So this one always makes me laugh, but basically it means if it's 12 o'clock at night and I'm not awake, you'll understand and respect that I'm not awake. Or if I'm with family, it means I'm with family, right? So it's an opportunity for you to set some boundaries with your client based on whatever your schedule is. When I first got started as exclusively a buyer's agent, I took Wednesdays off. It's my family day. I told them in the buyer's consultation, that is not my working hours. If you want to show a property on Wednesday, it will not be me. I'll find someone else to show it for me. So you can set whatever parameters you want. And then consultation. So they are consulting with you before visiting any properties. This is a big one. So I usually talk about open houses there. Like, hey, let me know if you're going to open houses. Let me know if you're wanting to go view properties. Absolutely don't click one of schedule a showing on Zillow or Realtor.com because you will get solicited by an agent. And that will be wasting their time because you've already signed an agreement saying that you will exclusively work with me during this period, right? So it's a way to educate them, and you should. Because a lot of buyers early on, when I didn't take the time to explain that, I would find out after the fact that they were showing, like we're looking at properties with other realtors and they didn't really know how it worked because they didn't know how compensation worked. And they were wasting other people's time. That's also a risk of them writing a contract on something and me being out of luck. Because I'm not gonna hold them to it. That would be silly if I didn't set the expectation, right? So does that all make sense? Cool. General conditions. So this is all of us, the general conditions that we are both agreeing to, buyer and realtor. Equal opportunity basically means that we're not gonna discriminate in any way, shape, or form for any of the protected classes. And so that means I'm not gonna restrict showings or only show you properties based on socioeconomic status or anything like that. Race, color, sexual orientation, all that stuff. Notice of intended sale. This really doesn't apply to the buy side, but it does on the sell side. They have to give notice if there's any work that's being done. And that's for liens, for the purpose of liens. You don't want a lien slapped on after the fact. Legal and professional advice. Basically, this is stating that you as the realtor suggest that they seek legal, tax, and other professional advice relative to any real estate transaction. And you make no representation or warranty respecting the advisability of any transaction. And that you're not an expert in matters related to law or structural engineering. And I could go on and read it word for word, but the gist here is you are paying me to be a realtor, and that is all I'm acting as. I'm not a roofer, I'm not a home inspector. I may make recommendations based on my experience that you have things looked at or checked out by a professional. I could even refer that professional to you. But what I say outside of the realm of real estate, you're not holding me liable to. Does that make sense? So another CYA section that covers you guys. Default remedies is basically say, hey, if it defaults, realtor is entitled to recover any cost or expenses for litigation. Basically, if I sue you, that's I win, you also pay my attorney fees. So don't put yourself in a position to get sued, Mr. Buyer. I usually don't have that conversation. Except for the one buyer I had that was an attorney and he just laughed at it. Okay, cool. So this talks about minimum broker services. So this is basically your job description, right? You covered theirs, this is yours. You're agreeing to accept and present any offers, counter offers. You're assisting them in developing, communicating, negotiating, presenting those things, and you're answering any questions they have about all those things. So basically, it is your job to advocate on their behalf and present, interpret, explain answer questions, all that stuff. Any questions there? Cool. Signatures, this is basically stating that signatures can be electronic. Yeah, it's pretty self-explanatory. Then. Franchise, this box you will check. We are part of the franchise. You always check that box. Use that. Here's that term, effective date, again, awesome. So we already learned this, but the effective date shall be the date of final acceptance hereof, as indicated by the date adjacent to the signature of the last party to sign this contract. So like I said earlier, it's the last date and time of the last signature is your effective date. Make sense? You can specify another date here if you choose to. I did this early on, especially when I was doing bold, because I was having to sign all these buyers, but they weren't gonna be transacting in the next 8 weeks. So I was like, hey, why don't we do this? I'll go ahead and get all your paperwork done now. We'll go ahead and put in your start date for October 1st, because that's when you plan on looking. That way we'll have this step done. And I can go ahead and connect you guys with lender to start working on your credit and whatever you need to work on in the meantime. That way you guys can still reach out to me. Does that sound fair? And that's a tie down, by the way. Does that sound fair? And they say, sure. And they sign it and you get them signed and it's future business. You're already secured, right? You can do that all day long. Make sense? Cool. That's the only instance where I use that. This automatically filled it in. Yay, Keller Williams Realty. So this is your information. So you would put your information as the agent here. So for me, I would put Brian Stone. I put my email, the office address, and then my title, which would be broker salesperson. So that's what I would fill out, right? You do the same just for your stuff. Address is the same, broker's the same, your title is realtor. Unless you're a broker salesperson, in which case, welcome to the club. This side is the buyers. So I don't know, it says Brian Stone, but this is me as the buyer signing and then email and then buyer to buyer's address. This section here, don't sleep on this. This is the designated agency section. So when we talked about the different agency types, we talked about the exclusive designated agency, being a checkbox. This is where you designate that. So you're gonna put yourself and anyone that is a part of your representation. So if you're on a team, whoever your lead listing agent is, or your rainmaker, or whoever it is whose name is gonna be on the contract or who's helping you facilitate the deal, their name will probably go there too. So my team members, they write their name and they write my name. And that gives me the ability to still have designated agency and step in their stead if I need to, right? But by default, if it's just you, you're gonna put your own name. If you're going on vacation and you want to have some coverage, guess what? You can pick a coworker that they don't have to be on your team. You could call me up and be like, hey, Brian, I'm going on vacation. I'm gonna be out of the country in Cabo for a week. I'll have 0 cell service, but I have buyers that are looking right now. I thought I'd find them something beforehand, but they might need some help while I'm gone. Can you cover me? Guess what? You could use this line to allow me to cover them by adding me into, even if we're not teammates. So you put my name here and then I could still represent them in your stead while you're away. I do that oftentimes with my teammates, even when I was an individual agent. I would always have someone that would cover for me and I would write them in to my designated agency section so that if needed, they could hop in and represent people if they needed to.
So you would do that ahead of time, like just kind of have somebody that's gonna be able to step in, okay?
Yep.
Or can you, I guess, come back and addend it later, I assume, if you
Yeah,
need
you can do
to.
an amendment
Okay,
and add them to it if it's unexpected, go, hey, I'm out of time, you do an amendment,
okay.
type that up. That's the legal way to do that. And it's the right way to do it, so. And then this signature is gonna be either a gem or not. You don't have to get the signature right off the bat. Once you get this scanned in, you have all the buyers signed, then you'll submit it to compliance and you can send it to them via DocuSign. They sign those all day long. These last 2 pages, if you're unsure about anything that we just talked about, just take these last 2 pages and it is a full detailed description of all the different types of agency, including the number of the statutes for the state of Missouri, that you can look up the statute itself as a reference point if you need it. If you're studying for class, it's also a good cheat sheet. You can hang on to that and kind of get a good understanding of agency because there will be questions about agency on the test. If you just review those 2 pages, that'll help. So, also, if you have trouble sleeping, this will knock you right out. Just saying. Start a couple paragraphs, out like a line. Cool, that is the buyer's exclusive agency contract. I went through that in an hour. But that was a big one. So any other questions about that? Clear as mud? Cool. Awesome. Let's move on to sales contract. So we signed the buyer, we're out showing houses, only the ones that they can afford. You guys want to repeat that back to me? Only the ones that they can afford. Yeah, good, smart. Okay, don't be that age. Only the ones they can afford. And then now we get to the 123 Main Street, and I call you guys as my agent and say, I love it, write an offer right now, I'm ready to go. This is the document we use, the residential sale contract. This is the most used document that you'll have. So anybody review this before? Someone familiar with it? Any big burning questions that we want to make sure we want to address, kind of like the last time where we talked about entities? So any things that within this contract you guys have questions about?
I'm a little fuzzy on like sellers concessions and yeah, just like what that's used for, what that means, but that's the only question I have on there.
Okay. Sessions, cool. I'll make sure I hit that. That's a common question. What else? Anything else you want to make sure we hit? Because we'll probably spend the bulk of the next 30 to 45 minutes on this contract. Because the other ones are all just kind of attachments or parts to this. This is the most important document. So any other burning questions or concessions? Cool, let's jump in. So we're gonna go back to documents. Add. And which of these packets are we gonna click on to find this document? Mar?
Oh, or probably under buyer.
Let's see, buyer? Nope. It is under Mar, but you wanna scroll through? Like, see the little thing? You can just go like this. Boom, everything with the word contract in it, there's a lot of them. So yes, you would be correct in saying Mar, you can search it, you can just search res. And you get all the residential contracts, there it is, boom,
Go under residential
Right there.
contract, okay.
you can do that, but you can also do residential contract documents, and it's right here at the bottom. So, which I haven't searched, you can search with any of those, but it's also all the way down here at the bottom in under this packet. But when in doubt, go to Mar and use the search field. But Res 2000, that's the document. So we're gonna add that in. We're not gonna cover all these CYA forms because they're pretty much self-explanatory. They just sign an initial. We can cover that at the end if we have more time, but we won't. So let's pull up residential sales contract. Cool. Hey, look at that. We already have some of our fields filled in. Yay, because of that autofill, the detail function, right? So it applies to every single document that's either in or you bring in. That is the best time-saving thing ever. Once you get used to DocuSign, you'll be able to fly through this. I can write an offer in about 15 minutes if I have to, if I have the proper preparation. Because I just get it all filled in and then fly through. I don't recommend you try and do that your first one. You should take more than 15 minutes, but it'll get faster as you do it. So all of that stuff's already filled in. We've got the buyer, we have the address here because we plugged it in. It doesn't have the zip code, so we'll add that in 65804. For whatever reason, that didn't carry over. So you still want to check these fields. This municipality field is kind of weird. They've changed this from what it used to be. The rule that I follow is just put in the city name. Because we don't technically have municipalities, but some other offices, non-KW offices, require this field to be in, or their compliance department kicks back and requests it from you later on. You have to do a correction, waste your time instead of going out to get more clients. So I do it on the front end. So if it's in the city limits of Springfield, I'm going to put the municipality as Springfield. If it's in Nix, I'll put Nix, so Zaragoza. Make sense? Cool. Most of the rural stuff out of town, you don't have that worry, but when in doubt, just go ahead and fill it out. right? So just go ahead and stick it in there. It's not gonna hurt to have the city name in there twice. So there's this part that says checkbox of legal description attached. Is there any instance where you would check this box? Answer is yes. But it's very rare in residential. The only time I use this box is if the legal description varies from what is on record for some reason. Or if it's a lot of land or a rural property, or if there's any kind of variance as far as the square footage and what's included, then I would attach the legal description here. Otherwise, I don't check this box because by default, you can see. See here, if no legal description is attached, then legal description on seller's vesting deed is to govern. So the easiest way for you guys not to add paperwork to your plate is just let their deed govern what the legal description is. Like I said, it's very rare. I can think of one example where I'm selling 3 parcels as one listing. That's one where I'm going to attach a legal description because I want to make it really clear that all 3 parcels are part of this sale, not exclusively the primary one that has the primary address. So that would be an instance where you would check the box and attach that description if there was some kind of instance like that, but otherwise, just leave it unchecked and it'll make it easier for you guys. Does that make sense? Cool. And then included inclusions and exclusions. I love this. I actually cover this document in my buyer's consultation before we start looking at houses. Why do you think I would do that? Is it anxious buying a house? I mean, yeah, is it anxious? Yeah, are people anxious when they buy it? I sound anxious right now, too much mountain. Yeah, I mean, it's a big process, especially first time home buyers. Do you always have the luxury of time when you're writing offers? No. If it's a hot property or the market is in a hot time frame, whatever, if there are your multiple offers in, and you have to have your highest and best in by 2 p.m. and it's 1:30, you're gonna miss it if this is the first time your clients have ever seen this document. I send this home with them and I cover this in my consultation because I say, hey, I want you to review this ahead of time. And I want you to highlight anything or circle anything you have questions about, so we can talk about it ahead of time. Because when we find your perfect home, this allows us to move quickly if we need to get you the best deal possible. Does that make sense?
Yeah.
Right. So, and this section is part of why I do that, the inclusions, exclusions. You want to make sure that they are aware of what is real property, what is not. You don't have those questions. Does the microwave stay with it? Does the fridge? What about the washer and dryer? How about the trampoline in the back? How about the cat? I've written in a cat, in a contract. That was fun.
Stop it.
Yeah, a kitten. I put it in the agreements. Yeah,
How did that go? I just need to know.
they got the kitten, of course. It's adorable. It was a mama cat that had just had 6 kittens right before the house listed, and the buyer wrote it and wanted a kitten. It's adorable.
It's cute.
Cutest contract ever. Should have framed it. But yeah, so but this by default shows your inclusions and exclusions. So, and there's some stuff on here that I would highlight. If you guys look at these paragraphs here, if it's in here by default, you do not have to restate it or state it on the included or excluded items down here. But some of these you want to pay attention to. Anything in here that you guys see that surprises you? You guys see anything that you wouldn't expect to be there? Or you wouldn't assume that a buyer would expect to be an included item? Which one?
The drapery hardware.
Drapery
I
and
didn't know
hardware?
that until I knew it was like a fixture.
Yeah. Curtain and drapery hardware only. So not the curtains, but the hardware. What do most people are gonna do when they move? They're gonna yank all the hardware down, leave the screws and the holes and the old paint in 3 layers, right? No, they're not. If they do, they're gonna have to put that back to a flat paint. or make some kind of compensation to the buyer on the final walkthrough if that's the case. This is super important to cover, and it's most commonly not covered. You could not cover it, but you might end up buying a fridge or a curtain rod or a TV stand. You might have to pay for those things because you didn't cover what needed to be covered. So cover this with your sellers and your buyers. What else is in there that you guys wouldn't expect?
Well, on the appraisal side of things, we would consider a window air conditioner unit as personal property.
But how is it listed here?
It's listed as included.
Okay, interesting.
Yep.
Some differences there, right?
Yeah.
So why is it considered personal property for appraisal standards?
You can open the window and take it out.
Yeah, because it's not attached.
Right.
Same as a fridge.
Yeah. Yeah.
Or a microwave that's on a countertop, but not a microwave that's
Built in a
part
stove.
of the vent hood that's built into the kitchen, right? So if you guys remember for real estate class, I'm glad you brought that up. It's the method of annexation, right? So like what makes it real property? But this contract trumps whatever your definition is, whatever the appraiser's definition is. This is the agreement between buyer and seller on what stays and what goes. It doesn't mean there's value attached to it, but it does mean that it's staying where it's going. So what else? Good call out. Thank you, Des.
What about solar panels?
I love that one. This one's a recent addition. So it says solar panels and systems.
Right,
Is that potentially problematic?
it is,
Why?
because they're not always owned. Sometimes they're still leased or they're financed.
Correct. Does this contract care?
It apparently does not.
It does not. It does not. And guess what? That means that seller is responsible unless they exclude it or otherwise modify the contract. By default, they're paying for that solar system, whether or not they live in that house or not. And they're gonna have to pay for it out of proceeds. If they don't have enough, then they're gonna have to figure out a way to do it. Because by default, this contract says that solar panels and those systems are part of that transaction.
There's actually a listing, it's still I mean, I think they're gonna have a hard time selling it, because part of the like contingency is that the new owner has to take on the loan for their
Correct.
like $49,000.
Yeah, and you can write that in to a listing. You can list a property that way. But then you have to make sure if they do receive an offer where a buyer's willing to do that, that it is explicitly excluded under line 20. You're gonna put in under excluded, solar panels and systems. And so if it's stated on the line, even if it's stated above, that's not unclear because the line below will trump anything that's up here. Does that make sense?
Okay.
So even if it's in this paragraph, if you write it as excluded, it's excluded. The other thing I want to point out here, this is in bold. I want you guys to read line 14 and 15. Somebody jump in right where it says note.
Contract and not a seller's disclosure statement, MLS or other promotional material provides for what is included in this sale.
Do you think it's important if they underlined and bolded it? Yeah. So, in that listing, it says that in the marketing materials. And then you go under contract. If you write them an offer and you don't put it as excluded as a buyer's agent, and that seller signs it, I don't care what the MLS says, come closing day, who's getting the solar system? The buyers, and they're not paying for it. And if the listing agent misses that, guess what? They're probably gonna be buying a $50,000 solar system. Or you're gonna have to go through litigation to figure that out. So this section seems small, but it's pretty serious. Make sure that you guys are paying attention. And I've had to call agents on that. I've had listing agents say, well, we put in there that the so-and-so wasn't included. I didn't put it in my contract. The contract we sent was what the buyer's intention was, and your seller signed it. So I guess you'll have to put the fridge back. Or I guess you'll have to find a way to get them a new oven, you know? But make sure you're paying attention to that.
So.
Questions?
Okay.
There's some other stuff in there too that's tricky. TV mounts. Would anybody assume that the TV mount wasn't personal property? Most people are gonna say, hey, that fits my TV. I bought it for that TV. When I take out the TV, I'm taking the mount out, right? But based on our contract, by default, the TV mounts are affixed to the property and they stay with it. The TV doesn't, but the TV mount does. That could be big money. You're talking about $150 to $300 per TV mount. You got a nice house that's got 9 or 10 mounts all through the house and the seller takes them all. That's a big discrepancy. It adds up. So
So by default, all of these are included.
by default, as it's listed, all those are included. Yeah.
Okay.
Yep. And there's some weird ones on there too, like mirrors. You see where it says, talks about bathroom mirrors.
I was just about to ask about that.
Attached mirrors and all bathroom mirrors. It doesn't matter if it's that really cute one that's an antique that you got from your Meemaw and your Peepaw. And you did a remodel and that's what the seller hung in there. Guess what? It stays. So my recommendation on the listing side is I tell my sellers, if there's something like that, that by default is included in our contract that you do not want included, move it out of the house now. Because what the buyer sees, they will expect. That's the easiest way to avoid stuff like that. Even like little mirrors, like the little decorative ones, where there's like 9 or 10 that are all hanging around like on the wall in the bathroom, technically all those stay. All bathroom mirrors. Super weird. If you came down to it, they could fight for it. Yeah. Your appraiser brain is like, that's dumb.
So on the listing side, you can't put that as like reserve.
You can. And if you get an offer where it doesn't have it on the excluded line and you miss it, when you present it and your seller sign it,
Yeah.
this contract and not the MLS or other promotional material provides what's included. This
So on the
trumps
listing
everything.
side, you better catch it.
You better catch it if you're gonna put it as reserve. That's why I opt, because I don't trust myself to do things.
Yeah.
I opt to tell them, let's take it out. If you don't want to include it, let's go ahead and get rid of it. Let's go ahead and replace it, swap it out, whatever. Right? Cool. I know I harped on that a long time. That's where most of the agents in our industry lose money. Because they buy things that they shouldn't have to buy. Unless it's an FHA buyer, then they better not be buying it. So. Included, excluded, all kinds of stuff. The only other tip I'll give you here, and this you'll appreciate, lenders appreciate too. Let's say, fridge. If we just put fridge, and there's a beer fridge that's like 1,000 years old, and then there's the brand new smart fridge that like orders your groceries for you in the kitchen. Which one's the seller gonna leave? The beer fridge. They're gonna take the nice one, right? So anytime you're doing fillable fields, make sure that you're super specific. So what I do is I would put fridge currently located in the kitchen at no value, to make it clear that we are not adding value on top, because an appraiser is not there to appraise a house and the smart fridge. And a lender is not loaning you money to buy a house and the smart fridge. So that at no value term will really help you from having to do corrections based on your lender. If your buyer's doing any kind of financing. So just get into the habit of putting it at no value. Anything that you have there that's included, just put at no value. Does that make sense? If it has value, then you need to do a purchase contract that's separate from this contract. For example, nightly rental, you're selling it furnished, right? All the furniture is not part of the real estate sale. Appraiser is not gonna be, they're not gonna take consideration of $20,000 worth of furniture, even though it may be worth it for you to buy it like that. You can figure that out outside of the real estate contract. Cool. Sales price, we're getting a deal on this. It's gonna be 50 grand. It's a foreclosure. Everybody in our office has owned this house at one point in time, so it's pretty rough. Concessions. So you had this question. So I have $0 in my bank account. But I'm a VA, I have a VA loan, so I don't have to put anything down. I don't have PMI, and I can have that and still purchase. So I need all my closing costs covered. And that's gonna be $5,000. So I'm gonna ask for $5,000 in seller concessions to cover. And I'm not gonna give any earnest money. So what's the difference between a seller concession and closing costs? This is probably where people get confused, right? This was your question. So what's the difference? It's okay, if you don't know, just say, I don't know. Okay, cool. What are closing costs? Closing costs is every cost that either the seller or buyer incur to close, right? And there's seller closing costs and there's buyer closing costs. So it's really important that you know the difference, because it's really easy to get that confused. Because your seller will like, well, why don't we split closing costs? Well, which closing costs are you talking about? Are we splitting the title fees? Are we splitting their closing costs? Are we paying for their insurance? Are we not, right? So because that's such a confusing terminology, seller concessions is much more clear, cut and dry. A seller concession is the dollar amount that the seller is conceding to contribute towards the buyer's closing costs. They are still responsible for their seller closing costs. Does that make sense?
Yes.
So that's the best way I explain it. And I explain it to my buyers too, because it gets really confusing. Well, they're, well, how much are closing costs? Well, it depends on the buyer and the lender and the title company and all kinds of things, right? Now, there are certain things that cannot be considered seller concessions. And you can actually see that. I'm going to skip ahead to section 10. So stick with me. Don't worry, we'll come back. We go all the way down to section 10. You can see adjustments / closing costs. Line 242, it is page 5. This is also a really good way for you to look and figure out, okay, well, to answer that question, well, what are closing costs? It actually breaks it down for you based on seller, buyer, or both. Really helpful section of the contract that you can refer to for your sellers or your buyers that have a question. It also talks about what cannot be included. So if we look here, let's see here. Adjustments charged for closing costs to be paid by all parties sufficient funds to satisfy their respective obligations here under as the date of closing. Such matters and following proration shall be itemized. A closing statement prepared before closing agent, executed by buyer and seller prior to closing. Okay, blah, 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 blah. Let's see here. Okay. Basically, this is all saying, hey, buyer is cautioned to always call to confirm instructions. Wire, okay, yeah, nope, never mind. That's not the section I thought it was. So we go down here. Oh, it's this one. 299. This is what you guys need to highlight. Sorry, I told you wrong. 299. Notwithstanding or foregoing, seller shall pay seller concessions up to, but not to exceed the amount set forth in subsection 3, which is that section that we just filled out. Towards buyer's closing costs. So it's that definition that I just gave you. Prepaids, inspections, lender fees, charges, and expenses. Title commitment, owner's policy, or lender title insurance policy costs and fees, i.e. title fees is how they're defined, that are paid for by the buyer, or any other expenses or fees associated with the closing, all as approved by buyer's lender, but not to include the cost of any home warranty, title fees paid by seller, or any brokerage or transaction fees charged by the buyer's broker. So those are the exclusions. So make sure that you understand that you can't like pay your transaction fee by requesting seller concessions because it's a buyer's fee and you're asking the seller to pay for it. That's not eligible. Same with home warranty. You cannot have a warranty come out of that. And guess what? If you ask for 5,000 concessions and the concessions that are actually billable are 4,000, what happens to the other 1,000?
Seller doesn't pay it.
Nope, stays with seller. It's up to. Buyer doesn't get cash back on, right? So only ask for what you need. It's really important when you're in negotiation to try and get those seller concessions to be as close as what they actually need as possible, because if you overshoot it, you're weakening your position in negotiation. Because if you need 5 and you ask for 7 and you don't use the 2, well, your buyer's out the 2. If you need 5 and you ask for 5, then you knock 2,000 off the sales price. Seller's already willing to come down, right? Make sure that your buyer's getting the full benefit of it. Does that make sense? Cool. And then again, it talks about prorations, closing costs, all paid by all the parties there in section 10. So we'll go back up to the top. Does that make sense? Did that explain your issue? Okay, cool. Awesome. The rest of the stuff is pretty self-explanatory. You're gonna put the title company here. So we'll just put America Title. What I used to do when I taught real estate school, because I couldn't use any actual names. Everything's patriotic in the Ozarks.
So I have a question, actually,
Mercantile.
going back to the seller concessions. So probably not a contract class question, but when you're asking for that, how do you? Like, do you usually ask, cause I recently had one and I just basically asked the lender, like, what are their estimated closing costs? And gave me a number, and so like, that's what we wrote in. So is that usually like a pretty safe rule of thumb?
Know your lenders well. If your buyer already comes with a lender, make sure that you have a conversation with that lender so you understand the limitations that you need to put in
Okay,
or parameters. One of those things is closing costs. One of it may be, hey, can they cover a gap in an appraisal? Hey, can they go above what their pre-approval amount is? If so, like, how much over, right? I ask questions like, what are your estimated closing costs figured on? And I ask for an itemized breakdown. Some lenders don't want to give that. It usually means that there's a lot of fees that they're taking in there. But lenders that you have a good working relationship, they'll give you the breakdown. We're like, yeah, we're estimating this number for taxes and this number for insurance and all that stuff so that you can really educate the buyer. Because there's a lot that goes into that. But generally, most good lenders can give you a good estimate. And it's probably going to be anywhere from 5,000 to 7,000.
okay, cool, thank you.
There's some that are on the high end, which usually causes me to question. And any of them that just say, oh, well, 3% or 6%. I never take that. I want a number because we can't write that in. So if you get a lender that says that, so, oh, that's what I tell other agents. Great. I'm gonna push back. What's an estimate? Give me a number.
I think the lender has to provide the buyer with a truth in lending statement, which should break down their costs pretty close. I mean, they're supposed to get that as close as possible for legal reasons for their buyers, so.
Yeah. A lot of buyers, though, they may or may not have had full understanding of all the stuff that they acknowledged.
That's true.
So it is our fiduciary duty to support their interest, which means the way I handle that is I have a really good working relationship with lender and I make sure that I know what the buyer needs to know because I'm operating in their best interest. Some lenders don't like to share stuff. There's a limit to what they can or can't share. If that's the case, schedule a conference call, get the buyers on there, get the lender on the phone. You can ask the questions you need to, and your buyers can give you an acknowledgement that they are okay with your lender sharing their financial information. So that answers your question.
Yeah, thank you.
Cool. Sorry, you asked me one question. I give you answers to 3.
It's okay, that's helpful.
So we've got title company, Merca Title. So this is just, hey, escrow agent. You're gonna write this multiple times. The escrow agent is the agent that's holding the funds. We don't have an escrow account for our brokerage. So we have all funds held, if there are any funds to hold, at the title company that's facilitating the closing. So for the purposes of you being at Keller Williams, your escrow agent is also your closing agent, which is also your title company. All of those 3 fields will be the same thing. It'll be your title company that you use. Does that make sense? Some people get tripped up on that. So I'm going to put Merca Title here. I'm also going to put it here because they're also my closing agent. Their address, weirdly enough, is right next door at 124 Main Street. Super sketchy. Springfield. And I put a comma and it already says Mo. Actually, I don't need a comma. Sorry. Some of these fields are weird. And we're closing on September 30th. Cool. You just put in your closing date, all that stuff. Makes sense. So make sure to Google if you're doing a 30-day close. What's 30 days from today? It'll tell you. That's what I do. And if it's not a Monday through Friday, pick a day that is a Monday through Friday and not a federal holiday because you want to make sure the title company is open when you're going to close. It seems self-explanatory, but there's a lot of people that just don't think about it. They're like, hey, 30-day closing. And you're like, oh, that's a Saturday. Or that's 4th of July. We can't do that. So, cool. I didn't talk about earnest money because it's 0, but you can write that in. And again, that's held. Earnest money, if it is taken, by default has to be delivered within 5 days. after the effective date. We already know what the effective date is, right? Which is the date of what?
The last signature.
Last signature, right? So within 5 days from when this is an executed contract, we have an effective date. If there is earnest money, it has to be delivered. So we're gonna go ahead and say that there is. We're gonna say it's gonna be $500. It doesn't have to be a lot. This varies greatly. I often, with my buyers, don't start with earnest money. If I'm not in competition, I use it as a leverage point to try and not lose their other terms that they want. So if the seller gets a counter or a funding negotiation, I'm like, well, what if we threw in $1,000 earnest money for security to give us the right to have those inspections that we want? So you can use it in that way. If they don't deliver it, they're in breach of contract. So make sure that they are aware that it needs to be delivered. And those funds are taken from their account. So only put earnest money if your buyer understands, hey, this is money that I will not have access to until I close, and then it will be a credit towards what I owe to buy this house. So it will go away and then come back if I do everything I'm supposed to. So that makes sense? Any questions about earnest money or how it works? Cool. We got that, we got title company stuff. Appraisal, yay. Sale contingency. It is either not contingent upon the sale or closing, or it is. We're gonna say in this case, it's not. If it is, then it tells you, hey, this is what you need to attach. Your homework after this class, if you want to get really good at all the additional forms that we aren't able to cover, is to highlight anywhere in this residential sales contract that has a form number listed and to look it up under the MAR section. Because this contract is super nice in that it tells you what the form number is to use in the instances within the different sections of the contract. Makes it super clear. So take advantage of that, right? If you're not sure what form to use, look at this contract first before you text Jim or Don or me. And if it says the form you need, look up that one first. If you have a question about that form, then you can text. Make sense? Cool. So we're gonna say it's not contingent, and we're gonna say we're financing, so we're gonna say yes, it is contingent upon appraisal. Now, this time frame right here is super important. In the appraisal contingency and the financing contingency, they're both there. This is the date that, after the effective date, that this contingency is still valid. And so if you have a 30-day contract and the default is 25 days, what happens if you get your appraisal back on day 26? Are we still contingent upon appraisal? No. Now, realistically, if they're financing, the lender won't loan, so it's probably a fall through anyway. However, the big difference is what happens to the earnest money, right? Because if we're outside of that contingency and there is earnest money in play, then technically speaking, that's not a legitimate contingency that the buyer utilized, and the seller could make an argument to keep their earnest money. Does that make sense? Yeah. So what I do is I extend it to the day of the contract. If it's a 30-day closing, I put 30 days. If it's 45, I put 45. So we'll say it's a 30-day, even though it's not, it's like a week, but we'll say 30 days. So I'm gonna extend that. And I'm gonna do the same thing in the financing section right here where it says 25 days. I'm gonna say, oh, it's 30 days there. So my recommendation is always that you extend the appraisal contingencies and the financing contingencies through the day of close. That way your buyer is protected. So, make sense? This time frame here afterwards, it basically says, hey, if the parties don't reach an agreement to reduce the purchase price as requested within 5 days by default after the delivery of the appraisal notice, then this contract shall automatically terminate with earnest money being returned to the buyer, subject to subsection 8, which is the earnest money section we'll talk about later. So this is important, but I usually leave it as 5. And you notice here, it tells you what to do. Hey, the appraisal came short. Crap, Brian, what form do I use? Guess what? You would use note MSC 2020N appraisal notice part A for this purpose, right? The contract tells you exactly what form to use. Sound good? Awesome. Financing contingency. So there's three different check boxes here. It's either not contingent upon financing, non-conventional, or conventional. Can it be checked not contingent upon financing and the buyer still get financing? Yes. It's not a commitment to not get financing. It just means the contract's not contingent upon it. So, in this business, it's my second or third to last soapbox moment. This is your weapon and your shield for your client. The one who knows the contract best wins, right? So I know I'm kind of harping on little stuff, but make sure you have a full understanding. I have gotten deals done that I otherwise wouldn't by putting not contingent upon financing, even though the buyer's intention is to seek financing, but I want it to present as a cash deal. But I have someone that could buy cash, but would rather get a loan. Is that valid if I put that? Yeah. Seller might think it's weird that we have a lender involved, or well, hey, I thought it was cash. I didn't say it was cash. I said it was not contingent upon financing. Right? There's smart ways to use this to be your advantage, okay? I saw some gear turning, went, oh, okay. So let's say it's non-conventional. So what's examples of non-conventional? FHA, VA, USDA, MHDC, all the alphabet soups, all the government loans, right? Those you would use a government loan rider, and it actually has the government loan rider here listed. The government loan rider is very similar to this section right here. The conventional section is just a separate rider that also has an affidavit. And I can show you guys that here in a second. So make sure you're using that. You can also do loan assumption, seller financing. There's all different kinds of stuff. If it's conventional, you can just check conventional and put in these terms. Here you would put the terms. You've got the loan percentage or the purchase price. This is not the amount down. This is the amount remaining. If they're putting 20% down, you would not put 20% here. You would put 80%. Does that make sense? That trips people up too. And I always recommend doing the percentage and not the dollar amount, because it makes it really clear if you have a counter offer and there's different terms, you want to have a lender say, hey, this number doesn't match what the contract price is. Well, technically you don't have to change that, but it makes it a lot easier if you just put a percentage. So they're doing 5% down, 3.5% down, whatever. If it's 3.5% down, you're gonna write 96.5 in here. So you do the inverse of what their down payment is. Make sense? And then here, you're gonna do interest rate not to exceed. And again, I have some great lenders that will tell me when they get their pre-approval, write in not to exceed this interest rate. They won't say this is what interest rate they're going to get, because it's locked in with the house, not the person. And they may be looking for a while. This is not showing their interest rate to the seller. It's another contingency within the contract that you can utilize to benefit your buyer if rates go above whatever their qualification threshold is. Does that make sense? We could have those rates spike. So I always err on the side of caution, and I'll put above whatever their percentage is, but I'll make sure I have a conversation with the lender. So I know, hey, what's their rate threshold? What do I need to write in? A lot of agents don't take that step, but again, you might need to use it. If rates are at 7 and they only qualify at 7, and if it's just an inch above, they're right at their debt to income ratio, then they're not going to qualify. You want to make sure that you have that in here, because if you write it at 8 or something like that, then you don't have a legitimate way to get them out if they can't finance the loan. So that's misinterpreted a lot.
Well, I just did a FHA loan rider for mine, and obviously I got with the lender because I, didn't know, and he was like, oh, we should be safe at 7.5. And I was like, okay, but
So, yeah.
that
So
makes a lot of sense. 'Cause
what he
I'm
was
like, okay,
saying
so that's
is-
not saying that's
yeah.
their rate, it's saying.
Because they're probably sitting at like 6.8 or 7 or 7.2, it kind of fluctuates, but anything above or below that, they feel comfortable with.
Okay,
Yeah, because the government loan rider is the same way. It's still not to exceed set rate. Yeah. Amortization term, you're gonna put it 25 years, 30 years, 15 years, whatever it is, you're gonna put that. If it's other, you can put other. The only other thing I would put as far as other terms here, oh, yeah, I think fixed if it's fixed. You can also put this, all other terms determined by vendor. Some people like to put that in. It's a good best practice. You don't have to. Not a huge deal if you don't, but if you got any kind of weird deal like a 2-1 buy down or an arm or anything like that, it's usually a good idea to check that box. Keep in mind, if you only check that box and you don't put an interest rate up here, which some people do, it removes that contingency. So make sure that you're careful when you're doing that. Cool. Tyler survey, moving right on. The option is almost always C. Basically, we talked about closing cost earlier and what closing cost, right? And the title fees paid for by the seller is one of the things that was excluded. You guys remember that from section 10? So this is telling you who pays for what. C is not 50-50, but the reason it's most common is because it's seen as most equitable. The cost is in line with ownership. Basically, seller's responsible for the past, i.e. title search, buyer's responsible for the future, i.e. owner's policy. Those are two very different price ranges. The owner's policy is much more expensive than the title search, which is why this is seen as more equitable. You wouldn't do 50-50. If you did 50-50, your seller would actually be paying more than what is really required of them. That's why we typically have C as our option. But it can be any of these. If you want to sweeten the deal, if you're an investor, or if you're buying a deal cash and you want to offer to cover that, you could be D. You could say, hey, buyer's going to pay for both. We'll pay for the search, we'll pay for the commitment, all of that stuff. It can also be the opposite. Hey, we'll pay you your listing price, but you're gonna pay for the owner's policy for the buyer to reduce their closing costs. You can do that too. But C is the default. And then here again, title company. Same thing, we write it all the time. America, whatever it is, title. All right, this section here is not commonly used. It has to do with the title commitment. I usually leave it here by default because it's 20 days from when it's received. The title commitment comes from the title company. It's usually within about a week or two. That's the title search. They're gonna let you know, hey, there's an easement, or this property line is clouded, or if there's a cloud in title for ownership or anything like that, it's gonna come up with the title commitment. This is another contingency in the contract that's not often used. There are a lot of instances where it's really necessary. So don't brush over that because it's important. And when you get the title commitment, review it. If you don't know how to review it, call any title company, especially the one you're doing business with. They teach classes on it, or you can call one of their staff, their closer, or their marketing people, and they'll walk you through what a title commitment is. They'll even walk you through that first one you get and explain how to read it. Because it's good to understand what those are, so you can share them with your client. So I'll give you a good example of that. I was able to use that to negotiate a really good deal for a lot that I bought, because we found in the title commitment that there was an easement for about 1.5 acres of a 5.5 acre plot that was sold to MoDOT, Missouri Department of Transportation. And the seller before the seller that was selling the lot to us took payment for it. But it wasn't on record for tax records, but we found it in the title search. Actually, I found it and I handed it to the title company because I checked it out. But you can do searches on MoDOT. But we use this to renegotiate and slash the price almost in half.
Whoa.
Yeah. Yeah, it was cool. It was a cool deal. I came out looking like a rose. I was like, yeah. They've sent me like 6 deals since then. It's been awesome. It's pure luck. It just happened to be a really bad recording. But yeah, sometimes you'll find that stuff. So it's good to pay attention to that. Or maybe there's a shared easement or a shared well that you weren't aware of that wasn't represented, and that may impact your buyer, and they may not want to have that as part of their property purchase. And this is a way to get them out if you need to. It's rare that stuff comes up, but it's there. Let's see, here's survey and title commitment objection. So basically this is saying, hey, you have 20 days to review it. And then this is how long you have to object it. And guess what? If you do that, it gives you all the ways to do it. If seller fails to timely respond to the objections, the seller shall be deemed to have refused to agree to correct any of them. And if a contract is terminated under this section, then the earnest money is to be refunded to the buyer. So all of that stuff is important to know. Inspections, cool. All right, we're coming up. We got 13 minutes left. So clearly I'm not gonna get to all those other forms. Inspections. There's gonna be three main sections, I guess, that I want you guys to worry about. Property data, your inspection time frame here, and then the limitation box. Those are the three things that we're gonna hit. I will tell you what I typically do is 0. I typically do this as 15 as a standard practice. And I typically check this box. Now let's go back and explain what all that means. So this has to do, this whole section, section 7 has to do with inspections. The way I explain it to the buyers have, and the sellers that I have, buyers have a right to do as many inspections as they want within the inspection period, but they can only submit an inspection notice once. Meaning you can't like have your general home inspection, ask for repairs, get a specialist, and ask for those repairs, and get a specialist, and ask for those repairs. You only have one shot at asking for any repairs. So that time frame is important. That's this time frame down in here, the inspection notice timeframe is 15 days is what I put. It's 10 by default. 10 is not a lot of time, especially if you're in a rural area. Know the property that you're writing an offer for. If you anticipate having more inspections based on its condition, give yourself or your buyers more time. Negotiate for that on their behalf. You'll be glad you did. So that's why 15 is my default instead of 10. Because that's not 10 days to do the inspections. That's 10 to do the inspections, get them back, fill out your inspection notice, have your buyer sign it, and then submit it to the listing agent for presentation. That's a lot to happen in a 10-day period, right? Especially if you have a 5-day vacation in the middle of it. So make sure you're aware. So let's talk about, back up and talk about property data though. Want somebody to read that paragraph for me. Loud and proud. Not all at once.
Within, and how many number of days do you put in there?
Just say 5 for now.
5. Within 5 days after the effective date, the buyer may review additional data regarding the property, including but not limited to zoning, regulations, taxes, school district, square footage of land or improvements, and the presence of registered sex offenders or other convicted criminals in the area. If unsatisfied with any property data, buyer may terminate this contract by delivering notice thereof to seller prior to expiration of the property data review period.
Cool, and it gives you the form to use and tells you that if you don't provide it, then you're basically waiving such termination rights. You're moving past it. So thank you for that. So all of those items are considered property data. Are those objective or subjective? It's one of my favorite things to talk about. How close is too close to a registered sex offender?
Yeah, that's subjective.
What makes a school zone acceptable or unacceptable to your buyer? What crime are you okay with? Right? Ooh, that's scary, right? That's tricky. So, and I see a lot of agents break Missouri state statutes when they get into this section. Especially when I was in school, they're like, no, it's your job to tell them if that's a good neighborhood. Absolutely not. That's illegal. You learned about it. You're steering them. Because that is you making a determination of what is a good or bad area. That is the hot water you do not want to be liable for. Don't get yourself into it because that's all subjective. What makes it a bad area? Is it the socioeconomic status? Is it maybe the school zone? Maybe it's the color of skin that people have that are in that area. You could be sued by trying to make recommendations on this stuff. So stay out of it and say, hey, all this stuff is subjective. What I want you to do, this is your time frame to review the area and determine if it's a right fit for you. And don't make any determination or steering there, just stay clear of it A lot of agents mess up on this. Absolutely don't step into that. I take this section really seriously, if you can't tell. Because you can get yourself in trouble.
You put 0 days typically,
I put 0 days.
you don't move back out or?
Well, so the problem with this being subjective is if my buyers want out, there's no teeth in a seller saying otherwise. Because I could just claim it's any one of those things. Yep, property data, we don't like the school zone, we're out. I call this the walkaway clause or the buyer's remorse clause, right? It is a super duper flight risk. So as a listing agent, what I expect to see is a small number, as small as possible, ideally 0. Otherwise, I'm not recommending that my seller take their property off the market for your client if they have the ability to walk within that 5-day period. So I would ask as a listing agent, why don't you have your buyers do their due diligence before you write me an offer? And then come back with something that's closer to 0 days, if not 0 days, right? So that's how I handle it. And I tell my buyers on the front end, hey, we're gonna do all our due diligence on the front end to make sure that you feel comfortable. And if you don't, by all means, let's put a number in, but let's try and get it as small as possible. I mean, how much time do you need to review it? We need 3 days, 2 days, 1 day, all of that is better than 5,
Okay.
right? So. See some concerned looks. Does that all make sense?
Yeah. So for your buyers, if they're sure they like the area, 0 days makes sense because, they're not gonna change their mind and it's appealing to the seller. Okay.
So,
If there is question, then you do give them a little bit of time.
yeah, and I think I'm gonna interpret your concern there because a common assumption is, oh, if I'm advocating for the buyer, I want them to have all the options. If I'm advocating for the seller, I want them to have none of the options. You're advocating for the buyer's interest. Period. And that's subjective. So you have to understand your buyer. If it is their interest to not lose this house and they're in competition and they absolutely are comfortable with the area and they want it to make the most competitive offer possible and they want leverage on other things like price. So this is something that doesn't cost them anything if they're already comfortable with the area, then you're advocating for their best interest to recommend 0 days. If that's the case, you just have to have a consult with the buyer. Does that make sense?
Yeah.
So just be really clear on what your client's intent is when you're getting into some of these options for fields, because it could all be different based on the buyer's needs.
That makes sense.
If it's an out-of-state buyer and husband's in town, but wife is out of town, and she wants to see it after she gets in town in 2 days, but they need to write the offer now, I'm not putting 0. I'm gonna give them some time to actually review it and get a chance for wife to come in, they can drive the neighborhood, check out the town, make sure that's what they want. Right, so there's different scenarios where you would use it. but-
Okay.
Yeah, so inspection notice, we talked about the time frame specialist report. So this by default is 5 days. This one can get people in trouble. Just know that you have to actually get the specialist to get the extension. So this would be, home inspector comes in and says, hey, recommend that a qualified structural engineer review the foundation of this home and address as needed. Because your inspector is usually a generalist. They're not gonna know absolutely everything about everything. So in that case, we get that inspection. We can submit for an additional 5 days to give us time to get that specialist in. Does that make sense? That's what that's for. And it could be HVAC, it could be roof, it could be anything that would be considered as a specialty. But if you go past your 15 days or 10 days, whatever your time frame is here, and then you don't have that specialist come and you don't get that report and you don't submit it with your inspection notice, guess what? You no longer have a right to that. I had that happen on one of my deals. I had a buyer that backed out and said, well, yeah, I want to get the foundation checked. And I explained to him there's a cost. Well, we passed day 15 and then he decided, no, I just want out of the house. I'm not going to pay $150 to have a structural engineer come in. I said, and what did he actually do in that instance? He accepted the property as is. Now I got him out still, but contractually speaking, he was past his inspection period because he didn't utilize the specialist timeframe that he needed to give him that extension, which means the first 15 days still apply. So make sure you're only extending if you need it. Don't extend it just to have more time because you didn't get your paperwork in order. Make sure you're paying attention to timelines. Does that make sense? Cool. Limitation box, this is huge too. So the best way I describe this is, do you want the option to walk away regardless of the outcome of the inspection or not? Because if this box is checked, the buyer is waiving, his or her right, or their right to just exit the contract after the inspection is done. Because if it's checked, you have to submit a notice and you have to give the seller an opportunity to respond to any repairs that need to be done. You don't have to agree to the response, but you have to give the opportunity for the seller to negotiate. Or if this is not checked, I could have an inspection, it'd be perfect and say, I'm out. So another flight risk, similar to property data. So if I'm on the listing side, I'm going to see this as a less favorable offer if this box is not checked. Because I see it as an easy way for the buyer to get out. And I want my sellers to have a right to respond to whatever needs to be responded, even if that means we need to fix things. We don't want to take our home off the market if there's going to be a risk for the buyer not to give us a chance to fix things. Does that make sense? So explain that to your buyer too. And the way that I word this as a question is, hey, Mr. and Mrs. Buyer, is there anything that we could find in an inspection that you would be unsatisfied with, even with the right to request it to be repaired or replaced to your specification? And I know that was really wordy, but because they can dictate that in the inspection notes, but you can only request things that are in writing. And sometimes that's the case. I've had a buyer from California and she said, I want no mold. I said, okay, you're not gonna buy a home in Missouri. Well, you're literally breathing it right now, but she wanted no mold. And that was her, going into this, that was her non-negotiable. She's like, even if they find it, I'm walking away from the house. I said, okay, then in good conscience, I'm not gonna put this limitation box in here because that's an item that would come up in writing that you wouldn't want to give the seller an opportunity to correct because you still wouldn't be satisfied with it. So we're gonna leave that open. And it made it harder for us to negotiate, but that was me advocating for the interest of the buyer. That was her non-negotiable, right? So it's important to ask those questions when you're talking with your buyers. Most of the time though, do I?
Can you like
Yeah.
say it how you say it again?
Is there anything that we could find in an inspection that you would be unsatisfied with, even if you were able to get it repaired or replaced to your specification? So, you get it?
Yep.
It's really wordy, so. Cool. That's inspections. All right, we're gonna move through some of this other stuff. Capitulation, resolution. So after you submit the notice, then you're in your resolution period. This doesn't start until the notice is received. So if you have 15 days in your inspection period and you submit your notice on day 2, because the inspector's super fast, guess what? Your resolution period starts on day 2, not on day 15. And it's 10 days from when that inspection notice is sent. That is your resolution period, not your response period, your resolution. So you can go back and forth with the seller as many times as necessary in that period to negotiate which repairs will or won't be done. But at the end of that period, that's when you get into capitulation. And that's a big fun word that most people don't use in everyday language. So essentially what it means is if you don't come to a resolution within the 10 days, your buyer has a right to still proceed. That's what capitulation is. So, and by default, I think it's 2 days. Yeah, 2 days. So let's just say seller has a backup offer that's like 10,000 more. And they're trying to bully a buyer out of it by saying, well, no, we're just not gonna repair anything. And then they'll fall through. We just won't respond to them and be a jerk. And then they'll fall through. We'll get 10 grand more, right? A legitimate thing that could happen, they could try and do. This prevents that from happening. You can hold the seller to it by saying, okay, if you're not gonna repair anything, we choose to capitulate, we give the proper notice with the form that's listed, we're proceeding to closing without you doing any repairs. Does that make sense? So it gives your buyer some teeth. If for some reason there's something else that's going on. This didn't used to be in there and I am so glad it is because I have had sellers that have tried to do that. They tried to just wait it out when the market was real hot because they got 2 or 3 backup offers that were better prices. So that's a real contract strategy right there. Way to go lawyers for adding that in. Okay. This just has to do with government inspections. It's pretty straightforward. I don't ever have to change anything here. It's basically just the seller complying to anything that's needed. A lot of that comes into play with new construction. They have to have, occupancy permits and all the required documentation there. The broker role just talks about the broker and the licensees and what their role is in the transaction. Basically, it's saying hold harmless for anything that's outside of their control and all that stuff. They're immune from liability. Another CYA thing. Home warranty. So we already learned that home warranty cannot be included in concessions, but this is where you would put it in. If you want to advocate for a home warranty, you can choose option 2. If it's already included, you can choose 3 and then list what's included. This one's pretty self-explanatory. Have an idea of what the home warranty cost is beforehand, because just like seller concessions, this is another concession. They're not buying the warranty for your buyer. They're conceding the dollar amount that's listed to go to the home warranty, and it cannot exceed that amount. So if you put in 500 and the home warranty is 450, the seller's only gonna be paying 450, but it's gonna come out of the closing docs. So, and we're a little over time, so I'm gonna speed through the rest of this. All of this we already covered. It was adjustments for closing costs. This just states that it's binding, and that it can be modified as long as everybody agrees. Talks about what happens if we default. The seller disclosure statement, make sure that you are checking the box and having that signed with the submission of your offer. If there's not one, you can choose option B, and that's another contingency. Basically, you're requiring the seller to provide it within 1 day by default, or however many days you put in, and then you have 3 days. So that gives you, guess what, a 4-day walkaway period without having to have property data at 5 days. I have used this in negotiation to give my buyers a walkaway period. So do yourself a favor as a listing agent, put the seller's disclosures up when you list so that a buyer's agent can't take advantage of your seller like that. So walkthrough, this is basically talking about the walkthrough. The buyer has a walkthrough up to 4 days, 4 days or closer to the closing. So as early as 4 days prior to closing, they can walk through. And it's basically stating that the purpose of the walkthrough is not for new inspection, and only the buyer, its representatives, or, and this is a big one, any inspector whose report prompted the request for a repair is allowed to walk through the property. It's not another inspection. Has to be the same person, not even the same company. If it's just a different home inspector, nope, has to be the same inspector. And it has to be something that's negotiated so that they're verifying that it was done to their satisfaction based on how we negotiated it. So, and make sure you're doing this if you have inspections, or at least you're recommending it. There are some home inspectors that charge for re-inspections, and there's some that have that included in their fee where they offer free re-inspections for anything. If you're planning on having a re-inspection, you may want to consider that when you're recommending home inspectors to your buyer. Because it's important. Inspect what you expect, because if they sign off on that final walkthrough saying, yep, we walked through, we're good, and the repairs aren't done to satisfaction, they've already released the seller's liability at that point. They've accepted the property in its current condition. Other than that, we've got all our riders here. These are pretty self-explanatory. You check them if they're there, you don't if they're not. You can add others if they're not represented. Again, like I said earlier, I recommend downloading or looking and printing at all of these forms because they're the most common ones that you're going to use. Not the subdivision review rider, that's super uncommon, but the government loan rider, the contingency for sale and contingency for closing, which is what you're dealing with if you have a seller that's also buying. Those are really commonly used forms. And then you have your special agreements, which are very subjective, so we won't cover that right now. But if you have special things, then that's typically the field that you use. The licensee personal interest disclosure, that's if you are you or any other agent involved in the transaction has a direct or indirect interest to any party in the transaction. So make sure you're filling it out if that applies. Sources of compensation, it's not going to be buyer, it's going to be seller. If they're paying your commission, the seller is, you want to make sure this is checked. And then here you type, like we said, we're going to have buyer's representation, also check for designated agent, and we're dual agenting or we're doing a FSBO, so we're going to do buyers and then limited, but typically it would be sellers. And then whatever this section is. You don't have to fill this out. You can also leave it blank and then you send it to the listing agent. Then they'll fill out whatever their representation actually is because they'll have more information than you will. If you're unsure about that, then don't fill it out. Better leave it blank than put it in wrong. And then people sign. You will always sign The buyer will always sign, the seller only signs if they accept, they initial if they reject or counter. Pretty straightforward there. And your acceptance deadline, you're gonna put this in. It's not a response deadline. The seller doesn't have to respond within the time frame. You can't bullet them into doing that. But whatever time frame you put in, it just means that after that point, your buyer's no longer obligated to the terms within the contract. So I typically do 24 hours by default. I can do shorter if if they have other properties that they would want to move to. Let's say they have two properties, they have a number one and number two. They may give 12 hours. And then if they don't get a response, then they're just gonna move on and write an offer on the other one. And then the seller can respond after the 12 hours, but they're not obligated at that point. So just make sure you're communicating that with the listing agent. That's it. We did not cover all the other forms. My recommendation for you guys is come to as many contract classes as you are able to. Plan for it. On top of Zoom. Thanks, guys. Thanks, Crispin.